I can't quite believe that YouTube limited my video on my main law channel talking about this Manchester airport incident. I had a few more thoughts on it, which I thought I'd share with you here on Secrets, but as I say, they limited my video there to 18 and over, and you had to be signed in. And I don't know really what for, because I didn't really show much of the scrap between the two individuals and the police officers. I used one or two choice words, but all of which I've now blurred out and cut out, and they've now released that video. So that is now fully open, and that's got hundreds of thousands of views. But as a result, there's lots of questions about it and a lot more about it. So I thought I'd talk a little bit more about it in this video. But it all stemmed off this bit here. From Reform threatening to do a private prosecution against these individuals. So let me show you this now, and then we'll talk a little bit more about it.
So we are therefore serving notice today in this letter to the Home Secretary that if the Crown Prosecution Service are not going to charge these assailants, then we at Reform UK, we will launch a private criminal prosecution against these assailants.
And there were lots of questions that came out of that. I mean, first of all, is it even possible for them to do a private prosecution, and what are the consequences, and how's it funded, and all of this sort of stuff. Now, I did cover a lot of this in my other video, but very broadly speaking, it is certainly possible. There is nothing to stop them from launching a private prosecution. My understanding is that it is first come, first serve, and whoever launches a prosecution just has to apply for a summons in the magistrate's court. They provide the details of the prospective defendant and the offences with which they are proposed to be prosecuted, and the magistrates or the bench will make a decision on whether to issue that summons, and then it proceeds in the same way as a normal trial would. Now, in response to this, there was obviously a statement by Greater Manchester Police. They updated to say, well, it wasn't really an update. They just came back to say, following the investigation led by Greater Manchester Police, major incident team, a comprehensive file of evidence was sent to the CPS in mid-August, and we await a charging decision. We've avoided providing ongoing commentary on the case. I'll explain why in a moment, including releasing footage to ensure that justice can be served without the risk of prejudicing proceedings. We continue to support the officers involved and are committed to getting them justice. Now, here's a bit that I didn't really talk about very much in my other video, but I will talk about here because I do think it's important. The police say here, we continue to support the officers involved and are committed to getting them justice. And I support that because without speaking particularly about the investigation into those officers, and without speaking specifically about the investigation to the two individuals and the ongoing investigation and whatever, for reasons I'll explain, I do support the police in getting justice for those officers who are in any other way doing their job. Now, there is obviously an investigation as to whether what they did amounts to misconduct and whether what they did amounts to any criminal offence. Many people have questioned whether that is affecting the ongoing investigation into the two individuals. Some people have questioned as to why it's the IOPC that's conducting this investigation, and some people have questioned why it is that they are investigating who leaked the footage of this incident at the airport. Now, if you're not familiar with the incident, I'm not going to play the video for you because obviously my video here would get limited on YouTube like it has done before. So I'll just have to talk about it in the round. You can find the footage, and it's all over the internet. You can find it and come back and watch this. Like I say, I don't know why my video got limited, but there we are. There is also a letter from Reform UK I'm going to come back to in just a moment, but just generally why people should be careful about what they say about these incidents is that if what you say, and there's a strict liability around this in the Contempt of Court Act, if what you say creates a substantial risk that the course of justice in the proceedings in question will be seriously impeded or prejudiced, then you could be held in contempt of court. There is a defence of innocent publication or distribution. Person is not guilty if at the time they don't know or have no reason to suspect that the relevant proceedings are active. But of course, in this situation, we do know that they're active, which is why I'm somewhat limited in what I can say. I can only comment very generally, but I can comment on what people are commenting on, although that's very meta. And I can comment on what's going on, for example, Reform UK threatening to bring proceedings. So I'll take a look at that letter, and I'll take a look at some of the questions that we've had come in off the previous video. But just before we get to that letter and those are the questions, just one other thing that I'd like to talk to you about. Now, some of you will know with the discussions I've had with you on these channels, particularly here on Black Belt Secrets, that I am somewhat of a private and paranoid person. Ironic, I know, since I'm on YouTube, but I do walk around with this inherent sense of security and being generally cautious about what I do, where I go, what I do with my information, who has my information, and that sort of thing. And so I do partner with companies on my channels from time to time, and one of whom is called Incogni. Now, I talk to you about these companies because I genuinely think that they will help you. And coming from someone who generally has a sense of paranoia about me, I am generally very cautious about who has my information and all these kind of things. Incogni is a fantastic company because I work with them because they help to remove your data from other companies that store it and sell it and market you as a package and so on. Now, the lawyer side of me deals with people that have had real problems in the real world where they've had loans taken out in their name. One client even had 15 mobile phone contracts taken out in their name because somebody had just enough of their information to convince these companies that they were them and take those contracts out. And by contracts, I mean they'd taken phones as well as the contracts for the SIM card, so they're making phone calls on these phones. They sold the phones and all that sort of stuff. So the reason I promote Incogni to you on these channels is because they will contact all these companies. They'll use UK law and US law to require that they remove all of your information from their databases. And it's a done for you service, so you don't have to do anything. You just sign up, you instruct them on your behalf. They will contact all these companies and they will require that they remove it. You get access to a dashboard and it shows you how many companies, hundreds of companies I've seen, saving me dozens and dozens of hours if I were to do this myself. And even as a lawyer, someone who knows how to do this myself, it has genuinely saved me so much time from insisting that all these companies remove my data from their databases. And it's an ongoing battle because if you want to communicate with people, they need to have some information, but then they sell it on and all these sorts of things. So if you want an easy way to get them to remove your data to help protect you from all these frauds and scams and general marketing junk, then check out Incogni, of course, as they are a partner to my channel. You get a 60% off an annual plan. Just use the link in the description below with the code BlackBeltSecrets and you'll get 60% off and you get a 30-day money-back guarantee as well. But once you see the amount of companies that have your data, they confirm that they've got it and they're removing it, it will absolutely alarm you. So whether or not, I'm not suggesting you walk around being paranoid and just being overly concerned about these things, but just take the steps to help to protect yourself as I do, and then ultimately that will help to protect you in the event someone tries to defraud you. So check out the link with the code BlackBeltSecrets and you'll get a 60% off, and that will give you fantastic peace of mind. Okay, so coming back to this letter now, this is from, you'll see that this is from Nigel Farage, Richard Tice, Lee Anderson, Rupert Lowe and James McMurdoch, who I regrettably mispronounced his name in my previous video, so apologies if he ends up watching this. But this letter to the Home Secretary, now some people have speculated that this is trying to put pressure on the CPS or the Home Secretary to do something about it. That's not how I read this. I read this as a letter giving notice that they intend to bring a private prosecution if the CPS do not authorise a charge. So this letter says you'll be aware of the very real concerns among the general public about two-tier policing and two-tier justice. While you and the Prime Minister try to deny its actual existence, you cannot deny the perception. That's fair enough. I've seen so many comments now that you certainly cannot deny the perception, if not the existence of two-tier policing and justice. Although in this particular case, as I did make the point in my previous video, that the police here were acting ostensibly with a lower amount of force than they could have used because they were firearms officers and they did not discharge their firearms. They used tasers. That's a factual account of what happened, not looking to derail any proceedings. But then it says here, this incident took place at the airport. Two men attacked the officers. Got to be careful with the words that I choose, otherwise my video gets limited again. There's clear CCTV evidence, and this is the point really. There's clear CCTV evidence showing exactly how this attack was on the officers. I'm picking out words here. Being a very serious offence. The assailants used such a high level of force One officer had an injury. You can read it for yourself. Some 11 weeks later, the assailants have still not been charged and are free on the streets. Given the aggression to the officers, they must be considered a risk to the public. Yet just 2 weeks after the incident, we saw that other people committed the same offence of assaulting police officers were summarily arrested, charged and jailed within days. Now, I also said in the previous video that's because they were charged and then pleaded guilty. But in this situation, they haven't even been charged. So obviously, a lot of people are upset that they haven't even been charged yet. This letter goes on to say that there is a very real risk and real concern that they are investigating the officers and trying to determine whether or not there's any fault with the officers to decide whether that's a reason not to charge these individuals or not to progress the case against these individuals. This letter says that that is totally unacceptable. The delay and lack of support of the serving officers is deeply damaging to the morale of police officers. I know this personally because I've had officers reach out to me and tell me exactly that. As well as impacting on their ability to do their job properly. If police officers are constantly working with the fear that their seniors and the IOPC will throw them under the bus, this letter says, at any moment, then they will not be able to protect the public in a full and fair way that we want. Now, speaking personally, as an individual, as a citizen, not just as a barrister and whatever, as an individual, I do want the police to be able to defend and protect the general public without fear or favour and without the fear of repercussions just for doing their job. That's what we would all hope really is the case. Now, obviously, if they do break the law, and obviously if they go well beyond the bounds of their duty and they should be charged with an offence or whatever, then that's obviously right. But generally, we want the police to feel confident in doing what they're doing. This goes on to say that if charges aren't brought, that they will institute private criminal proceedings against them themselves and crowdfund it if necessary. Now, I've seen some comments such as, why don't they fund it themselves and why should they crowdfund it? I think that's a bit of a silly argument because as individual MPs, crowdfunding it would be perfectly fine, or any other private individual would be perfectly fine to fund something like this. It used to be an offence, actually, if someone were to fund a claim or a prosecution and hope to gain something from it. That used to be called champity. That's used to be an offence, so you didn't used to be able to do that. Now, obviously, you can. But either way, I think it'd be wrong to criticise them for seeking crowdfunding or some other kind of funding to do that. But of course, all of this has given rise to lots of different questions, which have come up in this previous video that I did. So I'll link this so you can go and watch the full video there as well. Starting with a very simple question. No question is too silly or simple to answer. Someone says, who owns the CPS? Well, no one owns the CPS. That's the Crown Prosecution Service. That is our state prosecutorial body. It's a public body. It is formed under legislation created in 1986, I believe, and it is the state prosecutor. But that doesn't preclude anyone else from bringing a prosecution. So anybody, any private company, any private individual can bring a prosecution. Obviously, it has to get past the magistrate's court to issue that summons in the first place. And the way that works is very broadly similar in that it used to be called laying in information, but you apply for a summons and you provide the evidence pack to the court to show why they should be charged and brought to court for this offence. Someone else says, what's to investigate? It's all on video evidence. A bit like tweets and Facebook messages after the Southport riots. Why is it taking months to prosecute the airport thugs? But the fast track system was used for the messages. Now, just to clarify that very slightly, the only reason people were fast tracked in terms of their sentencing was if they pleaded guilty. The one thing I can't answer for you definitively at the moment, I can speculate without any risk to the proceedings, so I have to stay within boundaries. But what I can say is that what the police have confirmed thus far is that there is a comprehensive file of evidence which doubtless will consist of other body-worn cameras, certainly all of the body-worn cameras that the police officers were wearing, if that was activated, incidents before and after, intelligence that they were given before and after, none of which we are privy to. We don't know anything about any of that. For example, we don't know for certain, we don't know what the police were told when they were told to go and turn up, what they were doing there, what they said, all of this sort of stuff. We don't know any of that for certain, and I'm not going to speculate because that would come close to prejudicing proceedings, and I'm not going to do that. All I can speculate on is that is the kind of evidence that they'll put together in a file, and it's not just the video evidence. As I very often say, there is always more than one side to a story, and so just having one bit of the footage does not tell you the full picture. You might think it does, but it doesn't. It's just like when you saw the very first video. It seemed clear that the officers were acting in a certain way, but then when you see the second clip of video, it seems a much broader picture. You can see then potentially why the officers were acting in that way, and so on. And so if you extrapolate that out and there's a lot more information that you don't already know, then there's quite possibly a lot more to it than we know. And that's the only reason I can tell you that it's taking longer. But many will still speculate that it's too long and a decision should have been made by now. And again, I can't answer to that. That is for the CPS to decide. And if they haven't decided so, it does raise a lot of questions, which is why Reform are looking at bringing their own prosecution. Another interesting question here, as a nuance, says that so they are issuing a private prosecution on behalf of whom? So this is essentially an individual which will take on the role of prosecutor. So take, for example, a courier company. I won't name any particular courier company, but many of them do prosecute their own staff, usually for espionage or theft of parcels or interference and these kind of things. So they act as a prosecutor in the whole criminal process. They have to comply with all the criminal rules. They have to comply, for example, with the disclosure process, which is exactly the same. They will usually, ideally, have to have a disclosure officer. That is someone that will look over all the material that they have and decide whether or not it meets the test for disclosure. And that's a relatively straightforward test, a very broad test as well, and an ongoing duty of disclosure. And that encompasses anything that is reasonably capable, this is the test, reasonably capable of undermining the prosecution against them or assisting the defense. And so whoever brings the prosecution is essentially, they are the prosecutor, whereas the CPS is the state prosecutor. But other organizations prosecute as well. For example, HMRC prosecutes, the RSPCA prosecute, and as I mentioned, courier companies and indeed any other company can prosecute as well. Another interesting question. Someone says, I don't know if anyone's asked this, but how does double jeopardy work with private prosecutions? Well, that's exactly the same. I mean, the law applies in the same way, i.e. you can't be prosecuted twice for the same offence. That is why if there is a private prosecution against an individual, the CPS does have the authority to take over that prosecution and either continue it and run it as they would have had they brought it in the first place, or they can bring it to an end. So there's been a case that went to the Supreme Court when exactly this happened, where individuals were dissatisfied with how long the CPS was taking to make a decision. They hadn't yet reached a charging decision. So private prosecutions were brought, but in those cases, the CPS took them over and shut them down. The reason that case went to the Supreme Court was quite a nuanced reason, was that the CPS applied, from my vague recollection, a different test as to whether or not there was a case to meet, and so they applied a different test and then shut the cases down. The case went to the Supreme Court to see whether that was a reasonable test to apply, whether they should have applied that test. Supreme Court said it was fine, and so they were right to take it over and to shut it down. Someone else here says, can the Reform Party use a video from YouTube as evidence of a crime, or would they have to use original footage taken at the airport? Now, this would be for a court to decide. The court likes to go on best evidence. Now, ideally, they would go with the original source where the video originally came from. But if it's a YouTube video and it's a copy of the original source with video, unless it can be shown that it's been edited, it's probably fine. But the court would probably like to see the original video. And so they would likely go to the original source, which also raises the question as well as to what if there's lots of stuff that the police have gathered that the individuals don't have? Well, they can only disclose what they do have, and it would really be down to a conversation between them and the police, whether the police provide them with that evidence to bring that prosecution. Now, that raised a further question, which I thought quite interesting, and I'll probably end on this one, but a really interesting question. Someone said, what if the police have gathered lots of evidence and the individuals don't have it, but they want that evidence from the police? What would happen? Well, generally, my understanding is there is no direct obligation upon the police to provide that evidence to individuals that want to institute a private prosecution. They can, of course, request the material. The police could probably decide to give them that material. And they could also apply to the court for an order that the police release that material to them if they are considering that prosecution. In this scenario, it probably wouldn't go anywhere because the counter argument would probably be that the CPS already have it and they are the authority to prosecute on behalf of the state. They have the evidence and they will reach a charging decision. So the court would probably say, well, let's see what they say first. At the same time, the court might take the view, well, fair enough, you have the material, and if you want to bring the prosecution, you bring it. So really it comes down to what extent the police are going to cooperate with individuals with the evidence that they've gathered if they know the individuals are intent on bringing a private prosecution. And so hopefully that's addressed one or two questions that some people have had. Quite interesting questions. If you still have questions, please do leave them below. And please also remember to subscribe to this channel. We're here on Black Belt Secrets, where I speak a little bit more freely, but my next milestone is 150,000. Then I'm going quickly on to 200,000 subscribers. I'm really grateful to you all for subscribing, especially those of you that are around the world. I enjoy sharing my views with you here, and I'm very grateful for your company. So thank you for watching, and I'll see you next time.